The trio appeared in Nakawa Chief Magistrate's Court on Wednesday morning for mention of a case in which their lawyers challenged an April 4, 2025 decision of that court to have detectives cross-examined privately in favor of the request of prosecution. The defense contended that their case is of public interest and everything should be done in public and before the media. But the state reasoned that for the sake of national security, the interrogation of detective who had asked for court's order to hack into the mobile phones of the suspects could only be done away from the public. Defense has since reportedly filed an application at the High Court challenging that decision.
And the receiving court has to validate the filing. It is then endorsed by the registrar. It is allocated to the judicial officer, who has to validate it, and who, in their discretion fixes it for hearing.
However, the state contended that the lawyers of the accused persons had not informed court about the filing of the application and demanded to be served if defense had indeed done it.
It should be the defense that should be facilitating an expeditious process. But again, it is the contrary. This time around, Your Worship. This is not to castigate my senior colleagues, but just to say, you brief court, brief us on the state. We can't just be there to say it was filed. When was it filed? You were given 30 days. We could be here when the matter was filed yesterday.
30th of April is not 30 days from the 4th of April. So if we say that we have filed before the 30 days, I think he should be happy, himself having offered no support despite being commanded by the law to do so.
If that application was done by then, by now we would be informing court the state in which we are. Because we need to have this matter committed to High Court as fast as possible. But we are being held. This one is intended to frustrate the investigations.
After a lengthy counter-argument, the defense asked court to adjourn the matter to allow the High Court to fix a hearing date for the application filed. That request was supported by the state, and so the Chief Magistrate adjourned the case to 21st May 2025. Meanwhile, defense decried the manner in which their clients are being treated by prison authorities, claiming that they are handled as if they pose a threat to the public when they are actually innocent until proven guilty.
The court can take a look at that picture, where the accused person are surrounded by reasonable but mean-looking men. My apologies. If their dear relations want to greet them, they are sent away from afar, even beyond a distance of a long stick. Yet they have relations. They may want to speak to them. They may want to hug them.
The Hajat here is a wife to aide here. But even having a whisper, just a whisper, to his loved one or her loved one, is not allowed.
On the instructions of our clients, that they are allowed when they come here, starting from today, to have time to talk to their people, and that we are given at least 5 hours today to interact with Haji Obeid and Kanobis. They are human beings like us.
However, court did not address itself on this matter but instead considered the adjournment. Besigye and Lutale have been in detention since November 2024 after they were arrested in Kenya's capital, Nairobi. They are facing charges related to treason and are jointly charged with Captain Denis Oola of the Uganda People's Defence Forces. Daniel Kibet, NTV.